Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana. Now today we are looking at the Consumer Protection Act, which is a new and exciting area of regulation within our law. And what we'll be focusing on is the general aim of the Consumer Protection Act, what protections and rights it affords the average consumer, and if these rights are infringed, how the consumer can go about enforcing those rights. With me in studio to shed some light on the Consumer Protection Act, I've got Nadeem Mahomed of Nadeem Mahomed Attorneys, which is a very young law firm. Nadeem has 9 years of experience as an attorney, and he specializes in labor law and consumer-related legal matters. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to Legal Ease, Nadeem.
Wa alaikum salam wa rahmatullahi wa khairun, and thank you for having me.
It's a pleasure. Nadeem, what was the aim of the Consumer Protection Act? Why was it brought into effect? And just broadly speaking, what does it mean for the average consumer?
South Africa is a lovely country. South Africa has some of the most beautiful pieces of legislation, Labor Relations Act, the NCA, and now the Consumer Protection Act. And it is exactly what it stands, what it says, the Consumers Protection Act. So provisions and rights and regulations that protect the consumer. Obviously, it has certain provisions protecting the suppliers as well, so people who sell to the consumers. But in a whole, it's the consumers' rights to fair trade and transaction in the country. And I say in the country because it only applies, obviously, to transactions within the Republic of South Africa. So generally speaking, yes, it's aimed at equality and fairness and honesty between consumers, so the man in the street walking into a shop, and the supplier, the person who is selling him that service or selling him the goods or providing him the service.
All right. So to start it off, what would the Consumer Protection Act apply to? And we're just talking here the average consumer, what would it apply to?
Let's start from the beginning. The Consumer Protection Act was enforced in 2009 already. Hence, it's the Consumer Protection Act 68 of 2008. Some of the provisions came into effect on the 24th of April 2010, but the whole act came into force on the 31st of March 2011. So why that's relevant is because any transaction that was entered into from or on the 31st of March 2011 and onwards effectively is then covered by the Act. So broadly speaking, the Act covers any transaction, and I'll define all these legal words for you a bit later, but it's any transaction between a consumer, who is a person who enters into an agreement with one or more other persons for the supply of goods or services, or the potential supply of goods or services for exchange or consideration. So what does that mean? I mean, it sounds like complete jargon.
Yeah.
If you'd like me to explain it, I'll quickly give you a bit of a...
I think our viewers would appreciate that.
Absolutely. Brief example, all right? You're a consumer, okay? You're walking past... Okay, it's Eid's Day, it's before Eid's Day, you want to now go and buy yourself a new Eid's outfit. So you're walking past a shop in the plaza. In the window, you see a big white advertising board that says, get your brand new Egyptian cotton abayas and scarves for Eid, 35% off. Already now, that is a transaction, all right? Because if you see it, you're intrigued by it, and you enter that shop with the intention to comply with that marketing tool or that advertisement, a transaction essentially has been created. All right. Now you walk into the shop, you discuss the matter with the store owner. He shows you or she shows you the abaya or the scarf that you're interested in. You like it, you buy it, you go home. You are now a consumer for purposes of the Act. So now a transaction has taken place in that you are marketed to or sold a goods, an item or a service, and you now effectively have completed a transaction in that you've paid for that item and now have left to go home with it.
All right. So where does the Consumer Protection Act kick in?
Perfect. So now you go home, you trying out your new abaya and your new scarf, you put it on, and you think to yourself, hold on a second, this is not Egyptian cotton, this is actually polyester, or whatever it is. You decide you're taking it back to the shop. All right. Let's say it was 9 days after you wore it for Eid. 9 days afterwards, you realize this is not polyester, or it's not Egyptian cotton, it's polyester. You take it back to the store and you say to the store, "Oh, I'm sorry, but you told me that this was Egyptian cotton. It's not Egyptian cotton, it's actually polyester." The question here now is, whether or not you're entitled to a refund or exchange or replacement of the item that you purchased. Consumer Protection Act kicks in, and it says that you are.
You're entitled to a refund.
Correct.
A full refund, or can a certain charge be applied? I mean, assuming you used it for a little while.
Right.
Is there some charge that's attached to it?
Okay. So again, the Act is quite specific. Again, like I say, it's very nicely worded. It's very clearly and simplistically worded. But what it says then essentially is that you're entitled to a refund or replacement of the item at your expense and at your risk, and as long as you have returned it within 10 days.
All right. What happens if you fall outside of that 10-day period?
If you fall outside of the 10-day period, Section 55 of the Act and Section 56 of the Act kick in. And I can elaborate more on that. Section 55 is quite simple. It says that you have to be sold an item which is free from defect, in good working condition, is able to perform the purpose for which it was purchased, and can reasonably perform that purpose for a reasonable period of time, and must comply with the Standards Act of South Africa.
All right, that's a little technical. I think we'll have to just unpack that a little bit, but let's do that after the break.
Fantastic.
So we'll be back after the break where we'll look into a little bit more detail about how to enforce your rights in terms of the Consumer Protection Act. And so stay tuned, we'll be back shortly. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about the Consumer Protection Act, what rights it affords to the average consumer, and how they can go about enforcing those rights. And with me to discuss the Consumer Protection Act, I have Nadeem Mahomed. Nadeem, just one thing that I wanted to get to is, with most legislation that comes into effect, it doesn't apply to any transactions that happened prior to the date that the Act came into effect on. And in this case, you said that the Consumer Protection Act came into effect fully on the 31st of March 2011. So does it apply to any transactions that were concluded prior to this date or not at all?
It does indeed. Let me tell you first of all what the Act says, and then I'll explain it by way of example. The Act stipulates that if a transaction, all right, so qualified or defined as a transaction in terms of the Act, which, as I mentioned, is a person who enters into an agreement with one or more other persons, etc., for exchange or consideration, if that transaction would have been a transaction for purposes of an Act, purposes of the Act, and covered in terms of the Act, if it had occurred on or after the 31st of March 2011, and the transaction is a continuous transaction which would last for a period of 2 years up until the 31st of March 2013 or more, then the Act will cover that transaction. So for purposes of an example, you have a gym contract with one of the gyms. You take out the contract, let's say in 2009, 31st of March 2009. The contract is for a period of 4 years. All right? 31st of March 2011, the Act is in force and in place. 17th of April 2011, you decide, you know what, I'm actually not in the mood for gym anymore. I'm actually quite tired. I'd like to go and cancel my gym contract. The question is, can I cancel the gym contract? How do I cancel the gym contract? And do I have to pay a penalty?
Please answer the questions.
Thank you. So, yes, you can cancel the gym contract. What you would do is you notify the gym, the relevant gym, by way of letter. You would say that you entered into a gym contract on a specific date, that the gym contract would be terminated on a specific date, on the date when it should terminate, that you no longer want to continue with the gym contract, and that you would like the gym contract to be cancelled.
Can I stop you there?
Yes.
How is this position different to what would have applied prior to the Act coming into force? In terms of cancellation?
Prior to that, you wouldn't have been able to cancel a contract. You would be in
You would have been bound to it for that.
You would have been bound for the full period. And if you did cancel the agreement, cancel the contract, then what you have is a punitive measure against you, by which you would probably be liable for the entire cost of the contract. So let's assume your gym membership is 300 rand a month, times that by 4 years, and that's what you'd have to pay. The same with the cell phone contract. That position is different. Now, depending on when you cancel the contract in relation to the period by which your contract would run, you will be liable to a percentage only of the remaining balance of the contract. Percentages can vary. You're looking at between 60-70% of the outstanding amount. Most cell phone contracts will do that. Most gyms will have the same applicable provision. And most of these entities are aware of it now. So they still take their chances, but they are aware of it, fortunately.
Well, which is why I would like to educate our viewers so they can now say, well, the Consumer Protection Act says. Just in terms of going back to where you mentioned sections 55 and 56, which is where the consumer can return goods, where they're not happy with it for whatever reason, it doesn't entirely fulfill its function. How specific does the marketing have to be in relation to the aspect that the client is not happy with?
Okay. Let's remember the purpose of the Act, right? The purpose of the Act is to, and these are also form part of what is prohibited by the Act. So it's any transaction that is not within the purpose of the Act, and we'll get to that. Any transaction that misleads or deceives the consumer, or any transaction that causes the consumer to conduct him or herself in a fraudulent manner. Okay, those are prohibited by the Act and will be enforced by the NCC. So essentially the purpose of the Act, and a very learned legal scholar, Ifat van Eerden, says it quite nicely. He says it's to promote and advance the social and economic welfare of consumers in South Africa. So what that means essentially is that they are adequately advised, right? That they have a fair opportunity of understanding and knowing what it is that they are purchasing, or the service that is being marketed or advertised to them, and that they have an opportunity of understanding what is being marketed and the service that's being provided to them. That is in a nutshell what the idea is. So if you talk about marketing and how direct it has to be, the answer is quite simple. It must be direct. You cannot at any stage have a situation where that marketing or advertising is confusing. Okay. A very interesting example, and it becomes quite technical, and certain other acts, for example, the Electronic Communications Act come into place, but websites, for example, and compliance, legal compliance of a website. So does your website comply with the Electronic Communications and now with the CPA? So you log onto a website, you say you're looking for a car. You log onto the website and there are hundreds of cars, right? And they all have little descriptions. It's a 1975 or it's a 2010 BMW, for example. It has a certain amount of mileage on the clock. It has a full service history. It has mag wheel sounds, whatever it has. And you now are allured by that. So now you go to the dealer or you contact the dealer and you say, well, I'd like to buy this 2010 or 2011 BMW at the price that you market the vehicle for. And he says, cool. And you say, right, you've got full service history. And he says to you, yes, I have full service history. You purchase the car, you drive the car. Now a month goes by, and all of a sudden the car doesn't start. You're now in a situation where, one, you were allured by the marketing and advertising of that dealer. Two, Section 55, because Section 20 now is out of the question because it's been longer than 10 days. So Section 55 and 56 come into the picture, and you want to now take the vehicle back either for repair or for a refund. And that's essentially, to answer the question of marketing and advertising, it has to be strict. It has to be clear. It has to be non-ambiguous. And it has to be easy for the consumer to understand what he's buying.
All right. Well, in that scenario, do you have both those rights? Would you be able to ask for a refund, or would you be able to ask for that vehicle to be repaired?
Within 10 days, you're entitled to a refund at your risk and expense.
Yes.
That's Section 20. Later than 10 days, Section 55 comes into play. You're entitled for that item to be in working condition, free from defect, reasonably to be able to do what is reasonably intended to do, and for a reasonable period of time.
So, assuming the car is broken down, it's no longer able to fulfill any of those things.
Correct.
You're entitled to get it repaired.
Correct.
At the cost of the supplier.
Correct. And Section 56 now comes into place, and it says, within 6 months, if that item or the service doesn't comply with what Section 55 and the standards that Section 55 have said, then you're entitled to have that vehicle replaced or repaired. If it's unable to be repaired, so let's start with the first one. The supplier is now allowed to repair it at their cost to make it as it was advertised to you. Let's assume they can't repair it. Then they can replace it. Let's assume they replace it for you. 3 months down the line, it breaks down again. You bring it back. Now they have to refund you in full. So you see, there is a provision which allows the supplier to limit the expense, and thereby, obviously, the act is enforced.
All right. Let's take a break, and we'll carry on with this very interesting discussion after this break. Stay with us. It's getting complicated, but it's very interesting. Just such a broad number of rights that consumers now have under the Consumer Protection Act. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about the Consumer Protection Act, and I've got Nadeem Mahomed with me in the studio. What we have been discussing in the last two segments is how the Consumer Protection Act applies, how consumers can, or what rights consumers have, and some really interesting examples on what the Act applies to. Nadeem, I've just thought of foot stewards. How does that still exist in our law? Is that still a legitimate clause to put into an agreement, or does the Consumer Protection Act change that?
Foot stewards is changed substantially by the Consumer Protection Act. Let's take an example of the vehicle that you now buy. I utilize vehicles because, and not to say anything untoward against dealers, but I mean we've all seen certain television programs whereby dealerships were guilty of unethical behavior, so to speak. But you purchase this vehicle, right? And you drive it out of the dealership, and you drive 3 kilometers down the road, and all of a sudden, the car doesn't drive anymore. Now, let's look at Section 55 of the Act. Section 55 of the Act says that you're purchasing an item that for an intended purpose. So you're purchasing a vehicle, the intended purpose is for it to drive. If the vehicle cannot drive, well, then it cannot fulfill the purpose for which you purchased it. If you buy a vehicle and you sign a contract, and the contract says the vehicle is sold to you for stewards, you're not a mechanic. You certainly are not going to inspect the vehicle when you purchase it. So you buy the vehicle, you sign the contract for stewards, and you drive it out of the dealership, and a kilometer down the road, the vehicle stops working. You then tow it back to the dealership and say, sorry, but I want my money back, this vehicle doesn't drive. And then the dealership turns around and says, I'm sorry, but you bought the vehicle for stewards. It doesn't apply. Section 15 of the Section 20 of the Act is clear. Section 55 of the Act is more clear. 1, you're complied with the 10-day period, and 2, they haven't complied with the standards as per the Section 55 of the Act.
Mm-hmm. You mentioned inspections. If the consumer's taken certain steps to verify, that the vehicle, for example, is working, has had it inspected, are their rights altered in any way, or do the same sections still apply?
Absolutely, rights are altered. What has happened now, essentially, is you've been advertised or marketed a specific item or product. You then go into the shop or to the dealership in the vehicle, in the example of a vehicle, and you purchase that item. But before purchasing it, you say, I'd like to have it tested by roadworthy or an AA-approved testing, and you do it yourself. I'd like to drive the vehicle for a couple of weeks. I'd like to take it to my mechanic to inspect that everything is in order, because I know the CPA is there, but I'm not so sure how to enforce it, and I'm not so sure whether or not the CPA covers my right. So I'd like to make sure that the vehicle is 100%. You do all that. Certainly, if after doing all that there is still a problem or a defect with the vehicle, your rights in terms of the CPA, whilst they are still very much active and enforceable, might be substantially limited. If the vehicle didn't break down, or if you couldn't find any problem with the vehicle for a period of 6 months, but on the last day of the 6-month period, all of a sudden you realize there's a massive oil leak coming from the engine, you take the vehicle back, you say, listen guys, I did inspect the vehicle, I did drive the vehicle, and the vehicle has been perfect up until now. I'd like to invoke my rights in terms of Section 55 and 56 of the Act. You're more than entitled.
Okay, but after the 6-month period, that ends?
Again, after the 6-month period ends, and because it can't be perpetual, it can't be indefinite. Again, though, we must look at the third element of Section 55, which says that it must be able to perform its purpose for a reasonable period of time. a vehicle, let's say a brand new vehicle, you should have at least 50,000 kilometers in the vehicle before anything substantial comes into play. That's why vehicles are sold to you with warranties for 25 or 30 or 40,000 kilometers. That's why there's these motor plans. So if anything does happen, they usually fix it for free. You pay for that, but it comes with those things because that's the shelf life of vehicles, really speaking.
Right. So what is reasonable would depend on
the item.
Exactly. The other thing that I wanted some explanation on is I've heard about a cooling off period that the Consumer Protection Act has enforced. What is that?
All right. The Act, as you mentioned, as you remember, we talked about Section 20. So that says within 10 days, if you're not happy with the item that you purchased, or the service that's been provided to you, we must differentiate between the item and the service. It's not just to say that if you buy something, then the Act covers you. Because remember, we said a transaction is the provision of goods or services. So, for example, somebody services your vehicle. So it's your car, you take it to get serviced. If that transaction is also covered by the Act. So, to get back to your question, a cooling off period applies to where, so Section 20 then applies to where you now take the vehicle or the item back to the shop, to the dealer. Within 10 days, it's at your risk and at your expense, the consumer. The cooling off period says that you will take, and remember we said also Section 20, we might not have covered it, but Section 20 also says that you're entitled, you have to, explain to the dealer or to the supplier why you don't believe it to be for the purpose created, give him the opportunity to inspect why it does not cover the purpose, and 3, there might be an amount which you will have to pay to that supplier. So, and we were touching on it in the first segment, but if the item that you purchase is unpackaged or opened or utilized, the supplier is entitled to charge you a certain amount of depreciation value. But then again, if the item had to be opened in order for you to test to see if it worked, then his rights are then limited in terms of what he can charge you. Those things are all there in place, right? That's Section 20, and it says that they can charge you something for the return of that vehicle. The cooling off period is substantially different. Within 5 days after delivery, after the transaction is concluded, or you have taken delivery of that item, after 5 days, if you're not happy, you take it back and there's no questions asked. That's what the cooling off period says. So you have 5 days from the date of the conclusion of the transaction or from delivery, taking delivery of that item. So, for example, according to the consumer, she walks into a shop, she purchases an item, any item. And I'll tell you what items cannot be exchanged, right, which are exempted from the Act. But so she purchases an abaya and a scarf, and she now goes home. 5 days later, she says, I just don't like it. On the 5th day, she takes it back to the shop. She says, guys, I'm not happy. There's no questions asked. She doesn't have to pay anything. They'll give her money back, and that's the end of it. That's what the cooling off period says. So quite clear cut and quite simple. And 5 days is not a lot of time.
Excellent provision.
Excellent provision, absolutely. And also it applies to those direct marketing, to those advertising. You kind of knew what you wanted, but you weren't 100% sure. A travel agent, you see Mauritius, you see the Bahamas, you see Thailand. It's beautiful, it's clear skies, it's amazing. You're enticed. You want to buy it. You realize, hold on a second, I really can't cover the credit payments, installments on my credit card. 5 days down the line, sorry guys, I don't want this anymore. You take it back. They've got to give you your money back. There are some different elements relating to travel services and travel agents, but it's perhaps maybe for another show. It's too elaborate to discuss now.
Well, we're almost out of time. I actually should be wrapping up, but what I just want to briefly touch on is if the Consumer Protection Act applies to a certain transaction, you have rights that you want to enforce. Where do you go?
National Consumer Commission has been created to receive complaints from consumers who believe that their rights have been infringed upon in terms of the Consumer Protection Act by a supplier. So what does that mean? Exactly like this. Connie takes her item back to the shop. The shop says, I'm sorry, but we're not refunding this item to you. She picks up the phone, or she gets onto the net, and this is in the perfect world. She picks up the phone, she gets into the net, and she contacts the National Consumer Commission and says, guys, my rights have been infringed in terms of the Consumer Protection Act. I want justice. And that is effectively the principle. That's in a perfect world how it would happen.
And they would do the full investigation and they would take up the matter on our behalf.
Correct. They would obviously analyze whether or not it complies with the Act. So it didn't occur within the Republic. Of course, Fordsburg is in the Republic, fortunately. Is Connie a consumer in terms of the Act? Yes, she's a consumer. She was marketed to. She concluded a transaction. Was there a supplier involved? Yes, there was a supplier involved. And was there exchange? So, and when I talk about was there consideration, and consideration effectively is exchange for an item or service in value, and that value could be monetary, labor-related, by a coupon, a service, etc., or even a bartering situation. So yes, they will investigate, they'll make sure it's in accordance with the Act, they'll make sure that the transaction complies, and they would then go about doing investigation to determine whether or not her rights have been infringed. And if they have been infringed, again, in a perfect world, they would assist her.
All right, at their cost.
At their cost. Or at least at no cost to you.
Nadeem, unfortunately, we have to leave it there. Hopefully, we'll have you back to continue the discussion about the Consumer Protection Act. And it's been wonderful to have you. Thank you so much for being with us. Well, it's really been very exciting, and I think the Consumer Protection Act has changed so much about trading in our country. So stay tuned for more exciting programming to come, and hopefully more on the Consumer Protection Act. As I always say, please email me on yumna.bhana@itvnetworks.tv or follow me on Twitter at yumnabhana, and send me your suggestions for shows and your comments on today's show. Jazakallah for taking your time to watch the show. Thank you for being with us. Assalamu alaikum wa rahmatullahi wa barakatuh.